Greetings and salutations, my fellow sovereigns. This is the Vocational Science Freedom Saturday Night Civics and Sovereignty class. And tonight we are going to be continuing our reading of a treatise titled The American Law of Administration. And we left off at page 194. I'll just start off right where we left off. The devolution of property on the death of its owner. And part first, the devolution as determined by the act of the owner. Of testamentary disposition of property. The scope of the present treatise forbids an exhaustive disquisition on the laws of wills and testaments. And by the way, the word disquisition, in case anybody doesn't know what that means, it basically means an exhaustive or thorough layout of a particular subject. Nor is there any need for such an undertaking, the whole ground being amply covered by the able and thorough work of Jerriman, the fifth American edition, of which contains references to the latest American decisions relating to the subject up to the time of its publication, with explanatory comments by the American editor. But it is unavoidable to refer to the principles upon which the law is based and to incorporate into the present work some of the details bearing upon testamentary capacity, the form, execution, attestation, revocation, and probate of wills, as well as the appropriate time to point out the principal rules of construction and the principles upon which the will is carried into effect. Of the external limits placed upon testamentary capacity. So tonight we're going to be talking a lot about capacity and a lot about the presumptions that they use against us to deny us of capacity of our own will. Literally meaning our own ability to determine what we wish to do from moment to moment. Because as we read in the first episode of this series, will is everything. It is your capacity to do or not do anything. And it also is a requirement of property, because without will, you can't have ownership of property. And that's what they're doing. They are taking away and stealing our will by presumption and then probating our estates throughout our entire lives without us knowing about it. So, Section 17, limitation on the property disposition by will. It may be proper in the first place to consider what part of a man's property is subject to his testamentary disposition. In this particular, the practical development of the English law is not in strict harmony with the logical notion of property, which seems to be deemed a restriction of the power within narrower limits than are placed upon it in either England or America. Contrary to the progress of testamentary law in Rome, and on the European continent, which proceeding from practically unlimited power of disposition, the law of the 12 tables, to a limitation thereof, lex felicitia, the legislation of England has constantly enlarged the powers of testators in this respect. Now, I'm going to pause here, and I'm not going to go through an exhaustive read of the 12 tables, but it's not really that long, but I thought it was important for everybody to bring it up and to just take a look at it. 12 tables was laid down in 449 BC in Rome. And when you read it, you will see where the various different powers of wills come from. And there's a lot of other things in the 12 tables as well, like proceedings preliminary to trial, execution of judgment, paternal power. This has a little bit to do with the aspect of will, particularly this sentence, which is something that Tammy always brought up to me. It says, if a father thrice surrenders a son for sale, the son shall be free from the father. Now, it took me a long time to figure out what on earth that meant. But as Tammy described it to me, basically, if the father gives up the right to the child 3 times, then the child then basically ends up becoming open and able to be administered by whoever comes along, in this case, the corporate state. And the understanding of that, the first time this happens, obviously, is the signing of the birth certificate contract at the Foundling Hospital. Okay. So anyway, to continue, inheritance and guardianship, this is a lot about what they're referring to in the treatise. Ownership and possession, this also has to do with what they're also talking about in the treatise. Real property, torts, and public law, sacred law, which is like the beginning of ecclesiastical law, to be fair. And supplementary laws, and that's it. So 12 tables is not long. It's only 8 pages. You are all welcome to read it. It is the foundational document of Roman civil law, and I just wanted to add it for everyone's reading enjoyment after class. Okay, so without inquiring into the distinctions as to the various kinds of property which may be devised or bequeathed, and whether property acquired by the testator after the time of executing his will passes thereby, it is necessary to remember in this connection the various provisions existing at common law and enacted by the several states in favor of the widow and surviving minor child as limitations upon the testator's power over his property. These subjects will be treated hereafter in connection with the subjects of dower, support of the family, and homestead. Okay, so the reason I underlined homestead here is because in a lot of states, there is a homestead exemption, meaning an exemption that you can get that either completely gets rid of your property taxes, which I think Florida is one where you can completely get out of property taxes by a homestead exemption. And then there's other states where you have a homestead exemption that will allow you to at least pay far less. And I decided to look up Illinois just as a random state for no particular reason. So I looked up the Illinois Department of Revenue, and all I typed in was Illinois homestead exemption. That's it. But then you can see that you can just come and read the various different homestead exemptions regarding how much you can not have to pay or what the homestead exemption is to reduce your property taxes. Well, the reason for that is because this is all based upon the aspect of common law that your homestead is not something that should ever be taxed, because your homestead is something that is your domicile, where you are lawfully domiciled. It is not considered, or should not be considered, a residence, because a residence is a place where you're there temporarily doing business, which is why they label every single type of property tax as some sort of commercial endeavor. So when you're considered a resident, you're considered there to be doing business temporarily, and then you'll go back to wherever it is you came from, which would be your lawful domicile, also known as your homestead. Okay, so that's why I made a point of that, so that everybody can understand the importance of the homestead and in connection with what is one's lawful domicile. Okay, and so from this point, I'm just going to skip down to section 16 because we don't need to worry about, section 18, because we don't need to worry about Louisiana law. Okay, so section 18, limitations upon testamentary capacity. We have seen that the powers of testamentary disposition is an essential element in the nature of property, because the right to hold property includes the right to alienate it in such manner as the owner may, in the exercise of his free will, determine. It follows from this that every person may make testamentary disposition of his property who is capable, with reference thereto, of exercising free will. So, your exercise of your own free will is the determination of what happens to, or does not happen to, your property. Well, when they steal your will and they take away, by presumption, in the court systems, your capacity to have a free will, then the special administrator is going to step in and administer your entire gross estate for the totality of your life. So it's important to understand this. And again, this was very, very, very well covered in the first part of this class. But to continue. Okay, so but this definition of testamentary capacity, although perhaps strictly accurate in the abstract, is too general and vague to serve as a sufficient rule of law. Oh, really? Okay, attorney. Right. To enable judges and juries to act with the certainty and uniformity required for the purposes of justice in ascertaining the validity of testamentary dispositions, particular rules are established by legislative enactment and judicial authority, by means of which the law is rendered positive and certain, so far as human intelligence can make it. Okay, well, take a good look at the handout that I did for the totality of law class. What is positive law? What's the difference between positive law? Positive law and natural law do not touch. Natural law is you can do whatever you wish to as long as you don't cause damage, harm, loss, or injury to someone else or their property. Positive law, I'll blow this up a little bit. Positive law is thou shalt not because I say so. Okay, so never shall the two of these meet. And so what they're saying here in the treatise is, well, guess what? They're going to do it based upon that the law is rendered positive and certain so far as human intelligence can make it. So they're going to create positive law to determine what? To act in the certainty of uniformity required for the purposes of justice in ascertaining the validity of testamentary dispositions. Literally saying the ascertaining of the validity, meaning do you have the capacity to have a will or to alter and make a will? Either immediately, meaning you have a will when you're walking around, and to actually create a testamentary will. Okay, so to continue. These particular positive rules of law themselves established to carry out the fundamental principle operate as a limitation upon the discretional scope of judges and juries, without which the line of division between testamentary capacity and incapacity would necessarily be fixed by each person acting in a judicial character, which is what we should be acting as because we're all sovereign. But they don't particularly like that idea. And I just made a note here, as in positive law, not natural law. And I said, watch the totality of law class, which I cover and go over this entire handout that I just showed. Then on Odyssey, it's under playlists. And then you go to right here under the totality of law class and you can watch. It's an all-day class where I explain all of these various different aspects of law that I have circled or are in ovals in these different colors, okay? Because this is where people get messed up, is to not understanding what these various different things mean and which various different types of law are actually connected with each other and which ones are not connected with each other. You know, what has connection with other stuff and what does not. So like I said, natural law and positive law have nothing to do with each other. So I highly suggest that everybody go watch that class to get a better understanding of what they're talking about in here. Okay, so, all right, to continue. Now there, according to the personal impression of the moment, producing upon the community rather than the effect of a misleading ignis fatuus, which means foolish fire, then serving as a light to guide them in the knowledge of the law. Well, again, this is flowery language of the attorney saying, well, we have to be able to control what happens, right? Or else it would be a foolish fire, right? Allowing people to do what? Their own will. So just know that the attorney is literally saying that, well, if everybody just had their own will, that would be foolish fire. Yeah. Anyway, to continue. In the nature of things, such rules must be negative in form because they operate as limitations. Defining the general law as exhaustively stated in the general formula. Every person capable of exercising free will may make a valid testamentary disposition of his property. Well, good. That's what we should be doing. And my note over here says, and this is the extent and most important reason why all the vocational science of freedom status documents are created as a continuation of your will. Because, as I said, your will is being probated. And to make a point about that, if you really want to understand how your estates are being probated, the best class, or best two classes, I should say, to watch regarding that are How Your Estates Are Stolen by Fraud at Your Birth, Part 1 and Part 2, which are also on Odyssey, and they've also been uploaded onto Rumble as well. Because in these two classes, this is where I explain how they're doing everything as far as the administration of our estates. Okay? And it's much easier to follow, by the way, than this treatise. Because some of these treatises are a little bit difficult to read, and it takes a few years, probably, to be able to read these treatises in a way where you completely understand everything that's in it. It's taken me a long time to do that. And of course, you want to look up every single word that you do not know. Make sure that you look it up in Bouvier's Law Dictionary first. And then, if you wish to, you can look it up in Black's as well. But Bouvier's is the one that you should be using. But if you want more explanation, just go watch those two classes. Okay, so get back to here. All right. The first step will therefore be to state the proposition. Well, actually, hold on. Let me find this note here really quick. This was number 7, which is right here. Okay. So it follows from this that every person should make testimony disposition of his property who is capable, with reference thereto, of existing free will. All right. Number 7 is down here. Hence, in both states, all persons having attained the age of majority Right? Now, the term the age of majority is different than having come of full age. The age of majority is a term of the democracy, not the republic. Right? Or of 21 years. Not under legal disability are competent to dispose of their property by will. Okay. So, and my note here is, so only at 21 years can one be seen competent to dispose of their property by will. Now get this. Yet, the United States Code states that under 18 U.S.C. 1401, nationals and citizens of the United States at birth, and I'm actually gonna click on this because I have to be able to see it. Okay, let me make this bigger so that everybody can read this totally. Okay. 8 U.S.C. subsection 1401, nationals and citizens of the United States at birth. This is, so you're talking about 14th Amendment citizen here. The following shall be nationals and citizens of the United States at birth. So notice that. Anybody that's saying that you're going to be going and using the word national, it's not a good idea because they'll wrap you into this. Okay. So, A person born in the United States and subject to the jurisdiction thereof. Sound familiar? 14th Amendment. That's literally out of the 14th Amendment. But this is the interesting one. F, a person of unknown parentage found in the United States while under the age of 5 years, until shown, prior to his attaining the age of 21 years, not to have been born in the United States. Here is your presumption in the United States Code, right here in your face. This is a foundling. This is what they're doing. You're all considered to be foundlings. A person of unknown parentage found. What's a foundling? A foundling is a lost or abandoned child of unknown parentage. That's what a foundling is. Okay? But take a look at what the treatise is saying here. That hence, in most states, all persons having attained the age of majority or of 21 years, not under legal disability, are competent to dispose of their property by will. Okay, so they're saying that you have to get to 21 years in order to dispose of your property by will, but yet under the U.S. Code, when you hit 21 years, you're automatically getting thrown by presumption to be a citizen or being born in the United States, which is obviously DC, if you will. And it's not the States United. This is U.S. Incorporated. So the presumption is that you are a resident of the District of Columbia. So isn't it convenient that in the treatise it says, well, not until you attain 21 years, but then in the U.S. Code they say the second that you hit 21 years, the presumption kicks in that you're going to be a citizen of the United States. How convenient, right? All right, to continue. The first step will therefore be to state the proposition itself in its negative form. No person is capable of exercising testamentary power who is, for any reason, incapable of exercising free will. So what do? What do they make sure that they do first? They make sure that they get that presumption over you that you are incapable of exercising free will by labeling you as an infant, which is Title I, United States Code, subsection 8, under definitions. Go read the definition of the word person. It means an infant. So all of the United States Code, wherever they use the word person, they mean an infant. And that's the problem, because infants are not capable of exercising free will. They have a legal disability, is basically what the term is, okay? So, and this is what my note says, meaning that an infant cannot create a will. This is one of the most important reasons why we created the proof of life and proof of age inquest to be part of the vocational science freedom status doc set. This judicial inquest, I got to blow this up because there's more writing here. This judicial inquest by petite jury removes forever from you the presumption of infancy and death that the attorney uses to administer your estate. Okay? They're doing all this by presumption. So you have to get rid of the presumptions. Okay, to continue. So from which the classification of testamentary incapacity or of persons incapable of making wills because they lack testamentary capacity naturally arises. Manifold are the distinctions drawn in the numerous books which treat of this subject as the sources of testamentary incapacity. And I'm going to go down and look at number 1 here. Godolphin, in his Orphan's Legacy or Testamentary Abridgment, reckons 5 classes of persons incapable of making testaments. such as are by law prohibited for want of discretion as children. What? As children. That's infants. Mad or lunatic persons, idiots, old persons grown childish through excess of age, and persons actually drunk. For want of freedom, and this is the important part, for want of freedom or liberty, or that are not, what? Sui juris in all respects. So, for want of freedom or liberty, as in those who are subject to the jurisdiction of Congress, right? If you're subject, you are of want of freedom or liberty, are you not? Yes, you are. That is part of the problem. Okay, so then to continue down here, such as are prohibited by reasons of some legal impediments, as outlawed persons, persons at the very point of death, alien enemies, right? Does everybody know what that connects into? Alien Sedition Acts, what they did in the 1930s, right? Where they named all of the United States citizens basically enemy combatants, right? And such others. This classification, however, does not seem to satisfy, for he is careful to. But here note that all the said persons are not in all classes absolutely and utterly intestable, meaning the incapacity to make a testamentary will, but in some certain cases only as will more distinctively appear thereafter. And then I'm going to skip down here. Okay, to which he adds, not strictly subsumable under any one of these heads, the cases of aliens and of the reigning sovereign. Okay, so one must always ask in every case then, who is the sovereign and who's the alien here? Right? If you are under the presumption that you're an infant and that your whole estate is being administered, that you are a resident of D.C., that you are subject to the jurisdiction of Congress, guess who the sovereign is? The United States Federal Corporation. However, if you are out of there and by will have moved everything out and said, nope, I want nothing to do with you, you renounce, disavow, and get rid of your United States citizenship and bring everything back, and you being one of the people of whatever state you're from, California, Wisconsin, whatever, then you are a de jure state citizen, capital C citizen, lowercase s state. And then that will protect you, and that's what gets you out of most of, not all of, this mess. Because I think there will still be a point in time where we will probably either have to go to DC probate or perhaps just open a formal probate proceeding on the state side to pull everything back into our possession, which they've been administering in DC. Okay. So, all right, back up here. Okay, so manifold. All right, so I read that. It will be sufficient, however, for the purposes of this case, of this work, to observe the distinction between external limitations upon the will or disabilities created by the law in furtherance of what? Public policy. Not public law, but in furtherance of public policy. So, as in calling everyone an infant and only having that public policy enforceable upon infants, right? Because that's what public policy is. Public law is a harm. And everyone's subject to public law, meaning, can't murder someone, thievery, right? A harm. That's public law. Public policy is the administration of abandoned infant estates. That's all it is. And the control over corporations, right? That's public policy. So you got to know the difference between public policy and public law. Okay, to continue. And incapacity arising from the imminent defect of the mind by reason by which the person is devoid of the reasoning power and firmness of intellect necessary to realize his own will. To the former, belonging the legal presumption of want of discretion arising from infancy, and the merger of a married woman's personality in that of her husband, the incapacity of an alien to devise lands, etc. All right, so here's some of your incapacities. To the latter may be referred idiocy, lunacy, delirium, or any condition of weakness or unsound mind by reason of which a person's acts or conduct are not attributable to his own free will. Right. So this is what they do to you in court. This is when they go after you for what is called a fitness hearing, where the court will determine that you're crazy and unable to stand trial. But this also means that you are incapable of handling your own affairs and being in their inferior court system as the sole lawful executor and sole lawful heir of the estate the res of which is being administered in some constructive trust, which is the inferior court case itself, that the res of your estate is being administered and that you have the sole lawful capacity and highest capacity to say, wait a second, you're just a special administrator. I'm the sole lawful executor here. So everything that you're doing is a nullity because the heir has been found to be living and a lawful executor has been appointed to administer the estate. And that is not you, Mr. Blackrobe Priest of El, sitting up there with your Luciferian bullshit, making money and putting it into your 501c3 nonprofit religious trust fund, which is basically their retirement funds, right? And running everything through the IOLTA trusts, which stands for, which is an acronym for Interest on Lawyers' Trust Accounts. So, I mean, those two things are real, and you guys can go look those up. But that's how they're running everything, because all these private courts are private. They are not part of the state, which there's several federal court cases, which I have, which TJ Henderson was nice enough to give me, that specifically state that these courts are private. They have separate purses from the state, which makes them what? Able to be sued. They have no 11th Amendment immunity. They are just corporations administering your estate because you're not standing up and doing what you're supposed to be doing and saying, no, enough of this shit. All right. To continue. Section 19. Incapacity of aliens. The testamentary incapacity of aliens does not extend to personal property, and the invalidity of the devise of real estate by them arises out of their incapacity to hold real estate. Considerations of public policy require that no alien, whether friend or enemy, shall have title to lands as against the sovereignty. Right. So, if they're determining for you that you are an alien of the several states of the Union and that you are a creature of the District of Columbia, well, then guess what? Can you hold a allodial title to land in the states? The answer would be no, based upon what they just said here, based upon this presumption that you are an alien. Okay, so again, who is the sovereign here and who is the alien, right? But an alien may take land by purchase or devise and hold the title subject to the right of the sovereignty to procure an escheat or forfeiture upon information and office found. Until the land is so seized or the alien owner in some way dispossesses, he has complete dominion over the same and may convey it to a purchaser. But upon the alien's death, although he leaves heirs who would be capable of taking, if he were a citizen, the land escheats. Okay, what the hell does escheat mean? Escheat is a fairly extensive definition here that I gave to everyone. Let me scroll down. Okay, escheat, title to lands. According to the English law, escheat denotes an obstruction of the course of descent, right? Because land and property descends, goes by descent from heir to heir to heir. And a consequent determination of the tenure by some unforeseen contingency, in which the case of the land naturally results back by kind of revision to the original grantor or lord of the fee. Okay, well, luckily, we don't have any feudal tenures in America. At least there aren't supposed to be any. And you can clearly read that in the first Wisconsin Constitution, where it says that all lands in Wisconsin are allodial and feudal tenures are prohibited. Okay, so number 2. All escheats under the English law are declared to be strictly feudal. What? And to import the extinction of tenure. Number 3. But as the feudal tenures do not exist in this country, meaning America, there are no private persons who succeed to the inheritance by escheat. The state steps in the place of the feudal lord by virtue of its sovereignty. Well, not really, but anyway, as the original and ultimate proprietor of all lands within its jurisdiction. It seems to be the universal rule of civilized society that when the deceased owner has left no heirs, it should vest in the public. Now that I would agree with. And be at the disposition of government. Well, only from the standpoint that the government puts it up for auction so that somebody else can then, what? Hold the allodial title to it. That should be the only function in the republic that the government has. But this is the understanding of escheat, right? So if there's no one to have a proper will, or in the case and point up here, that either you're an alien or you're an incompetent, well, can allodial title transfer? The answer is no. So you have to get rid of all these presumptions before you can even hold allodial title. And this is what they're doing by that. And not to put too fine a point on it, Blue Star and I found a very interesting section of the original Michigan Constitution, which created what was called a board of escheats. Well, in the 70s, I think it was, or somewhere around there, they took all of the powers of the board of escheats and they put it under, surprise, surprise, the treasurer of the state of Michigan. Wonder why? Well, so that they can continue to administer all the lands without anybody finding out that, wait a second, they're all escheating back to the state because no one's claiming allodial title because they're not getting rid of these presumptions. So anyway, to continue. So this is the rule at common law according to which aliens cannot take real estate by descent or by operation of law in any respect. Very important. A change took place during the second half of the century, both in England and America, in the direction of obliterating the distinction between citizens and aliens in the ownership of property. Most of the states enable alien friends to acquire lands by purchase, devise, or descent, and to hold alien devise and transmit the same by descent, unconditionally, as in Alabama, Arkansas, Colorado, Florida, Georgia, Maine, Maryland, Massachusetts, Michigan, Missouri, Nevada, New Jersey, North Carolina, North Dakota, and so on and so forth. Or upon condition of bona fide residence in the state or United States, or appearing by the heir or devise within the time limited by statute, during which the claimant may become a citizen or sell the land before it escheats to the state. Right. But again, you have this problem where everybody's stuck as a 14th Amendment citizen. They're all considered to be subject to the jurisdiction of Congress. So even though these states did that, if the presumption is that you're a 14th Amendment citizen and that you're an infant, and that the presumption that you're dead, that they don't know where you are, right? So they're administering your estate by presumption of death. Well, then you don't have access to this, do you? No, you don't have access to the state laws because you're still an alien, okay? Okay, to continue. So skip down to the next note, because that just gets into more of the land laws as far as that's concerned. All right. Through the title of aliens to land within the limits of the several states of the Union, right? The several states of the Union. These are the republics, everyone. This is how this is supposed to be stated. Is matter of state regulation. Yet the treaty-making power of the United States includes the regulation of the transfer, devise, and inheritance of property in this country owned by citizens of a foreign country. Hence, a treaty between the United States and a foreign nation will control or suspend the statutes of the individual states when there is a difference between them. Okay, what are the original land patents? They are treaties. All of them are treaties. Because they're a treaty between the United States government and the sovereign who the original land patent went to. And you can see that in land patents when you go and read them, because in every land patent, there's what's called the addendum clause, which says to have and to hold to their heirs and assigns forever. Forever is forever, people. There's no ambiguity there. And they are treaties without question. So the original land patents state that. And because they state that, that's an aspect and understanding of a treaty, because they're all signed by the president at the time of the United States and given and granted to whoever it was that originally held the first allodial title to it. Many of them were transferred by what was called, they don't call it knight scoage, but knight scoage meaning shield payment. There was a lot of lands that were given to a lot of people, either during War of 1812, during the Civil War also, where veterans were given the land patents. So a lot of times you'll see land patents that it was given to so-and-so because of such service. Okay. And then other land patents will say by purchase, because the United States did sell the land for gold and silver, meaning lawful consideration back then, for the title. So anyway, I'll get off the allodial title. All right, so on to infants here. Okay, incapacity of infants. Section 20. The incapacity of infants arises necessarily out of their want of discretion. But the gradients of mental capacity are impossible of accurate measurement, and since it is impracticable to ascertain the precise moment when an infant's mind is sufficiently matured to act rationally upon the ordinary affairs of life, the law fixes a definite age before the attainment of which it conclusively presumes the want of discretion. Well, what's that called? It's called having come of full age. It means that you are capable to handle your own affairs. And that is exactly how it's stated in the Magna Carta. Go read the Magna Carta, particularly Articles 3, 4, and 5, and you will see where it talks about that when the heir comes of full age, they shall have their estate without fine and without fee. Meaning you can't fine and fee me for the use of my own property, which is basically what the entire system does all the time. Okay? But to continue, it is evident that whatever age may be fixed upon, there will be many whose mind is riper and better able to understand the nature of human transactions before they reach it than that of others who have passed this age. The limitation, therefore, is an external one based not so much upon mental incapacity, but arising out of a legal disability. And again, this is what they're always doing. They're always going at you with legal disabilities. The necessity of classing infancy with external limitations upon testamentary power is apparent also from the diversity of the rules laid down with regard thereto in the several codes. For at common law, male infants of 14 and female infants of 12 years of age were held competent to make wills in regard to their personal estate. Right. So this still applies. Why? Because in every state, at least every state that I've ever seen that gone looking into, there is a statute in each state that says that the common law of England is still in full force and effect, unless repealed by the legislature. So this is still in full force and effect in pretty much every state. So this rule was abolished in England by statute in 1838, which allows no valid will by any person under the age of 21 years, which is what we read above, right? The whole problem with the 21 thing. Whether of personal or real property, but in many of the American states, the common law distinction is still observed. So, what is it? Male, 14, female, 12. Probably because females grow up a bit faster than males do, and their brains develop quicker. So, common law distinction is still observed. Right. So, what are we doing? Following United States Code, or pretending that we're subject to the United States Code, and saying that, oh, it's only until you can become 21 that you can create a will? No, of course not. Bullshit. That is exactly the opposite of what this just said. Right? So, just remember that. It's important. Okay, in Florida and South Carolina, the statute fixes the age of 21 years as necessary to devise real estate, but is silent as to personal property. In Tennessee, no age qualification is mentioned for either real or personal property. Hence, the common law remains unchanged in each of these three states. In New York, males of 18 and females of 16. In Georgia, infants of 14. And in Colorado, of 17 years of age, Maryland parties, yada, yada, yada. Okay, I'm just going to skip down. But by far the greater number of states require a testator of either sex to be of full age. What? That is exactly what is stated in the Magna Carta. You have to come of full age. Okay, so now I'm going to skip down to section 23. Okay, so 23. Degree of mental vigor, requisite to make a will. The most important ground of testamentary incapacity, feudal, in abundant crops of litigation, is that of mental deficiency arising either from idiocy, lunacy, or other permanent or temporary disorder of the mind, inconsistent with the exercise of free will, or from such weakness of the mind as unfits it to resist undue influences, meaning like someone that would be suffering from dementia, say. So that the testator's disposition cannot be said to be his own spontaneous acts, but are rather the results of importunities, devices, fraudulent representations, or even the threats and force brought to bear upon him by designing persons, which would be sign it because you have to, which is basically what they do every single time that they throw you into jail. They say, here, sign this bond, or you don't get out of here. Well, fuck you. I don't want to sign the bond. Well, if you don't sign the bond, you're not leaving. All right. Well, I'm signing it under duress then. That's the whole point. Right? Or as in when a judge threatens you with contempt for his private for-profit non-court of record because you will not surrender your will to the filthy priest of El. Just another example. I'm going to hold you in contempt. Shut up. Objection. You can't hold me in anything because I've come of full age, and I'm the sole lawful executor of the res of which this court is unlawfully administering by executor de centort, which means executor of their own wrong. Okay, skip down here. It is conceded on all hands that no rule can be laid down to indicate the precise degree of intelligence or mental vigor necessary to constitute testamentary capacity. The nearest approach thereto is the requirement of the same capacity for testamentary purposes as for the transaction of the ordinary business of life. Okay, so if you can do your ordinary business of life, then you're fine, which is exactly the reason why we do and what we do with the Vocational Science of Freedom Proof of Life and Proof of Age inquest. It's not just a proof of life and proof of age inquest. It's also an inquest in the aspect of competency, because the jury, the petite jury, that's summoned by your judicial coroner of your own house, finds you to be competent by jury, by general verdict. And once that happens, it can never, ever be challenged again because it was done in a court of record according to the common law, of which a jury determined it. So that's it. End of story. No more. So once you do your vocational science freedom status doc set, if any judge ever tries to say that you're incompetent or tries to throw you into a mental ward, all you ever have to do is to go get a certified copy of the proof of life and proof of age inquest signed by all 12 members of the jury and file it into the court case. And then if he does not release you immediately, that is aggravated kidnapping. And then you can take it. I would take him directly to the Justice Department and or convene a 25-member grand jury and hang his ass. So, but to continue. All right, Section 24. Incapacity of idiots. An idiot is said to be a person wholly destitute of the reasoning faculty, unable to compare two ideas together, and utterly incapacitated for the transaction of any business. In later, I was going to skip this, but I'll read it. Early writers laid down very narrow tests of idiocy, such as inability to count 20 pence, to tell father or mother, or how old he is. Blackstone lays down the same rule nearly 2 centuries afterward, and Lord Hardwicke says that the term non corpus mentis imports not weakness of understanding, but a total deprivation of reason. In later years, courts of equity, both in England and America, have taken jurisdiction of persons who have become, from any cause, so weak and incapacitated in mind as to be unable to manage their affairs and place them under guardianship. This is your fitness hearing, people. This is what they do. If you walk in there and you don't have all of the vocational science freedom status docs done, and you start talking about what? Administration of the estate, being the executor, talking about what they're doing, saying objection maybe one too many times, or failing to state that you are the defendant, which is the thing that they really hate, they will bring up, or the attorney, usually the district attorney, will say, Your Honor, we come upon a verbal motion of competency, or we come upon a verbal motion for fitness, a fitness trial. You better immediately object to that. The first thing out of your, if you ever hear that, whether the judge says it or whether the prosecuting attorney says it, the first thing out of your mouth once you hear that is objection. Grounds, Your Honor. What are the grounds? Because they don't have any. And all they're trying to do is to force you into a fitness hearing to try to get rid of the fact that the sole lawful heir and executor actually showed up. Because if everybody does this, there is no more administration. So just be very well aware of that, all right? To continue. But in respect of the testamentary power, it seems that while the will of a person proved an idiot is of course void, mere weakness of mind, imbecility, whimsicality, or eccentricity is not sufficient in the absence of other proof of incapacity to invalidate a will. All right. 25. Incapacity of lunatics. Unless therefore a person is proved to have been an idiot or natural fool, some other evidence of incapacity must exist in addition to imbecility or weakness of the mind to invalidate his will. Again, this is also why we make sure proof of life and proof of age inquest that the petite jury also finds you competent to handle your own affairs. For once that fact has been ruled upon by a jury, no court in the United States can alter that finding of fact, which is what I said earlier. persons non competus mentis or of unsound mind, which terms are now generally conceded to mean the same thing, may be lunatics, distinguishable from idiots chiefly by the idiocy, or I might have butchered that, or partial nature of the disorder of the mind, while idiots are uniformly and wholly deprived of reason, and from imbeciles who may or may not possess sufficient vigor of mind to dispose of their own property according to the circumstances by which they are surrounded. While lunatics are not imbeciles, but affected by delusions, may have ample mental force, but exercise it in an abnormal or perverted manner. The importance of the distinction lies in the difference of the treatment of the issue of distavantant vel non and the evidence under it necessary to meet the case arising on the one or the other ground. For if it be proved that the testator was an idiot, this will invalidate the will. If it be shown that he was of weak mind, the question will be whether there was undue influence. Okay. And skip down to 27. We'll probably do 27, and then we'll probably end for the night. Sorry, I wasn't looking at chat here. If you guys have any questions up till now, go ahead. If you got to type them out, go ahead and start typing them out. So when I get done with 27, we can go over questions real quick. Okay, 27. Presumption of insanity. When such evidence has been produced to as will satisfy the jury of the testator's insanity before or recently after the execution of the will, it is, of course, indispensable to the validity of the will that it be shown to have been executed during a lucid interval or upon cessation, whether temporary or permanent, of the malady, meaning the craziness. If the proof of insanity consists in a degree to be non-compos mentis in placing him under guardianship, the presumption is and continues until be a degree or judgment by a competent court declaring his restoration that he is incompetent to make a valid will. Let me reread that again, because this is the black robe priest of El determining whether you have a will or not. If the proof of insanity consists in the degree or judgment of a competent court, that's just the black robe priest of El deciding it, declaring the testator to be non-compos mentis and placing him under guardianship, the presumption is and continues until there be a decree or judgment by a competent court declaring his restoration, meaning that he does have his will and he can take care of his own affairs, that he is incompetent to make a valid will, which also means that you're incompetent to have a will, meaning in the present moment, right? Doesn't just mean a testamentary will. It means you don't have any will at all. You are a ward of the court, in other words, or a ward of the state.
But this presumption may be rebutted by proof, which is why we do the jury thing ahead of time.
Exactly. So that proof is already done before they even try it, because they, trust me, they try it all the time. So, but this presumption may be rebutted by proof showing his sanity at the time of executing the will, although the guardianship be unrepealed, or the chancellor may, now what's the chancellor doing in here at all, right? If he is satisfied that such party is competent to dispose of his estate by will sense and judgment suspend proceedings against him so as to enable him to make a will, right? But again, this is why CLF3 just said that we take care of it beforehand. So there's a protection there so that they can't do this dumb shit. Okay? So we're coming up on the hour here. It's about 5 minutes to. So I'll make a note here to, this is where we'll come back to, and I will take a look at chat to see if anybody had anything posted, and just to take a look at anything else, what anybody did post. Yeah, you see how they constantly impose new phrases that use similar words but have entirely different definitions. Yeah, and law to trick you. This is them playing the legalese game. X age of majority versus full age, right? Precisely. If you want to see an example of someone dispossessing of a res of the estate by an act of will, look at the boom letter. Yes, the boom letter it's the first KW. It's what it started, the first kill warrant. And CLF3 wrote it, put it into the court, and the whole entire case disappeared. And if you want to look at that, I believe the proof of is in, I think it's under settle the estate. And then there's I'm not going to look for it right now, but there's a mega folder that you can then take a look at that, the first letter, because he redacted it. So everybody can see how it works. And we'll put in definitions of allodium, held in allodium. The antithesis of feudal, exactly. No feudal tenure. allodian, allodin, rare for allodial or allodian. Oh, it's just two different ways. Never seen those two before. Allodium, private and load a vassal that is without vassalage, right? Because there's nothing higher. If you're the sovereign and you hold something in allodium, there is nothing above you. End of discussion. An estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. Exactly. It is used in opposition to feudium or fief, which means property, the use of which was bestowed upon another by the proprietor on condition, which is exactly right, because everybody, the highest form of title, if you will, under Roman civil law is fee simple absolute, but it's still a fee, right? It's not title in allodium. So anyway, which means property, the use of which was bestowed upon another by the proprietor, a condition that the grantee should perform certain services, like paying property taxes, for the grantor, and upon the failure of which the property should revert to the original possessor, right? What we talked about tonight regarding escheat. In the United States, the title to land is essentially allodial, and every tenant in fee simple has absolute and unqualified dominion over it. Yet in technical language, his estate is said to be in fee, a word which implies a feudal relation, although such a relation has ceased to exist in any form, while in several of the states the lands have been declared to be allodial, which is exactly what I said about Wisconsin. Skipping down here, in some states the statutes have declared lands to be allodial. Also see 28 Wisconsin 367. That would be an interesting one to look up. I don't know if that's in the Declaration of Allodial Lands or not.
I'll look it up right now.
Okay, that would be fascinating. All right, in England there is no allodial tenure, for all land is held medially or immediately of the king, but the words tenancy and fee simple are there properly used to express probably what they have in England, and I'm sure this would continue. But that is fascinating. In some states, so it's not just Wisconsin, this is plural. In some states, the statutes have declared lands to be allodial. Well, shit. If we can go find other statutes in other states, which is obviously the Roman civil law side, but if the Roman civil law side of the statutes is declaring the lands to be allodial, well, that's it, folks.
Okay, here, Constitutional Article, Section 114, Wisconsin, by which all lands within the state are declared to be allodial and feudal tenures are prohibited, employs the word allodial in the sense of free from the restriction of alienation connected with feudal tenures. Hence, that part of the blah, 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 declaring any mortgage or other alienation of a homestead by the owner thereof, if a married man, will not be valid without the wife's signature, does not conflict therewith.
All right. Yeah. Makes sense. So yeah, but that's fascinating. So yeah, if we could find other ones.
That 28 Wisconsin 367 was a Supreme Court of Wisconsin Supreme Court reference.
Oh, okay. Okay. Nice.
And there's the link to it right there.
Very cool. Yeah, I will I'll grab this and I'll throw it into the committee on land rights. Just so I don't lose it. Make sure it's in there as well. Okay. Neat. Very cool. Oh, this is a Westlaw connection. Okay, cool. I was like, what's with the keys here? Okay. Well, again, as it said, it was plural. It said state, so there's got to be more of them somewhere. So probably be a good idea to go look. All right. Is there anything that anybody else wanted to comment upon or any questions that anyone else had? If not, then I'll pause it here and we'll come back to page 216 the next time that we come back to class. So I'd like to thank all of you for coming and participating at the Vocational Science Freedom Saturday Night Civics and Sovereignty class. And since we're doing 1 week on, 1 week off, we will not do it next Saturday, but it'll be the 18th is the next time that we will hold Civics and Sovereignty class. And we'll continue to tear apart this treatise on American law of administration, because it is certainly showing us a lot of interesting little tricks of their trade. So hope everybody has a wonderful rest of your weekend. As always, stay safe and stay sovereign.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and